worship or rituals. For most Indians, religion governs the relationship, their understanding of family, of property, of marriage, child rearing, etc. It creates what one may call a moral universe for its adherents. This is not only about rituals that come with marriage, but the very meaning of these words is different for Hindus, Muslims, Christians, Adivasis, and whole host of communities. It is not just about whether your marriage is a nikah or a 7 feras or I do in a church. Therefore, 1.3 billion people cannot be expected to be governed by a single law. To expect this is to attack pluralism. Pluralism, secularism in the Constitution can be seen in Article 25, 26, 29, besides 14, 19, and 21. This is part of our basic structure. This is what Abdul Ghaffur Nurani once called a mosaic. Our conceptions of a marriage of our family are so vastly different that it is unfair to expect that everyone should abandon it. Just as an example, a marriage in Islam is a contract. As such, both parties can set out any condition they wish to set out. This includes the wife setting out granular conditions on how the income of the household is spent, how the children are raised, and the conditions of what happens after divorce. In contrast, marriage is a sacrament in Hinduism. The very nature of these things is so different that individuals are likely to think of their obligations and rights very differently. It is not fair to force one to concede their understanding of marriage for another. For example, in 2016, the Supreme Court ruled that a wife refusing to stay with her in-laws is cruelty to the husband. Therefore, Supreme Court granted divorce to the man on this ground. In Islam, a woman has a right to separate household, privacy in the same household. Our Prime Minister, Shri Narendra Modi, has long seen our diversity and pluralism as a problem. He sees our distinctions and differences as a major problem to be resolved, which is why he believes in one nation, one election, one tax, one law, one culture, one religion, one identity. So much so that I recently saw that there is also now one nation and one fertilizer. But distinction or differences are not a problem of the Constitution. This is why Article 29 specifically says that any section of Indian society has a right to preserve their distinct language, script, or culture. Differences are to be celebrated. Commonalities also have to be celebrated. This is too complex a point for Mr. Modi, but it is what makes us a great nation. India's legal system must reflect the diversity of the country. One nation, one everything is not something that suits a plural and a diverse nation such as ours. This brings me to the next point, which is that if there is a uniform civil code, Muslims will have to give up on the above-mentioned distinctions in favor of a uniform civil code. That will be nothing but a Hindu civil code. All references to Islamic practices will be treated as illegal or unlawful, while all Hindu practices will be protected under law. The best example of this is the Hindu undivided family. In 2015 and 16, the Hindu undivided family tax exemption in income tax costed the Indian exchequer 3,064 crores. The Law Commission recommended that this system should be abolished. Why did the Modi government not do it? Why did advocates of uniformity and equality not campaign for this? In Kerala, Hindu undivided family has been abolished. Has any BJP proponent of UCC ever advocated for the abolition of Hindu undivided family tax rebate? Similarly, Section 21A under Special Marriage Act protects marriages and inheritance between Hindus. But the same is not extended to Muslims. Why? What we see is that uniformity is only equality for Muslims. For Hindus, it is culture, and therefore it is an exception to the law. There is always a Hindu exception to every uniform law. In contrast, in Islam, family is a far more complex system. Property is inherited upon death. While sons have obligations to take care of their aging parents, their wives do not become part of the joint family or undivided family. There is no concept of co-parsoner or karta. Every married couple and their children form a distinct familial unit separate from the extended family. Unfortunately, uniformity is a synonym for common. It is not a synonym for equality. It is not a synonym for sameness. BJP has used a sleight of hand by confusing uniform with common. Furthermore, equality simply does not mean the erasure of distinct cultural or religious practices that are available to each individual. This has significant implications. I want to give some examples of this. One, why are Buddhists, Sikhs, Adivasis, Jain, etc. all clubbed within the Hindu Marriage Act? There have been consistent demands from all these groups that they should not be governed by Hindu Marriage Act. Second, why do Adivasis have a Section 2 exemption in the Hindu Marriage Act? Why have they been demanding Sarna Code and the right to be identified separately from Hindus in the census? Clearly that their demand does not mean that they are not equals. Their demand does not mean that Hindus are being discriminated against. Their demand simply means the recognition of their distinct culture. A similar case is found for Nagaland and Mizoram under Article 371, which protects their customary rights. Even within Muslims, there are distinct legal schools and practices. Unlike British common law, Islamic jurisprudence is not based on precedent, but on case-to-case basis. The facts of each situation differ, and judges often evolve different solutions. Furthermore, depending on your own school of thought or sect, you have different principles of interpretation. Why should all these be subsumed under the same law? Law in books versus law in action. Most importantly, law is not a vehicle for social reform. If it were, we would not see 80% of child marriages from Hindus. Isn't there a law against child marriages? At least 9 million girls are missing in India as a result of female infanticide from 2000 to 2019. To compare, this is slightly lower than the entire population of Uttarakhand. 86.7% of missing female births are of Hindus, whose population is 79.8%. This is despite a law against female infanticide. National Family Health Survey data reveals that Hindus men who choose to have partners outside of marriage or were in relationship had 2.2 mean number of sexual partners in their lifetime. Sikhs and Christians had 1.9, while Buddhists and Muslims had 1.7 on average. Jains had the lowest mean number of 1.1. The National Family Health Survey 5 tried to find what percentage of men had intercourse with someone who was neither their wife or somebody they lived with. In the 12 months preceding the survey, as many as 7.8% of all participating Buddhist men said yes to this question. They were followed by Sikhs, 6%, Hindus, 4%, Christians, 3.8%, and Muslims, 2.6%. Similarly, polygamy is practiced by 1.9% of Muslims, 1.3% of Hindus, a difference of 0.6% despite the fact that it is legal for Muslims and not for Hindus. It is highest among tribals and Christians. Again, despite the fact that it is not legal for either of these communities, the point is simple. It is not the law, it is the social attitudes. Those women who have married partners are not protected by law, but second wives among Muslims are protected and have a right to maintenance. According to census, the percentage of separated and abandoned women is also least among the Muslims, 0.67%, compared to Hindus, 0.69%. Christians, it is 1.19%, and other religious minorities, 0.68%. There are close to 20 lakh Hindu women who are abandoned and separated. This number is 2.8 lakh for Muslims and 0.9 lakh for Christians and 0.8 lakh for other religions. If the goal is gender equality, then one must focus on education, job creation, social attitudes. National Family Health Survey has demonstrated that with an increase in education and wealth, there is an improvement in gender equality. For example, educated and wealthier women are likely to have planned pregnancies. They are more likely to take decisions by themselves. In conclusion, if the goal is to target Muslims and ritually humiliate them, then uniform civil code is imperative. But how far are we going to stretch the meaning of uniformity and equality when we have an Hindu exception for everything, while outlining everything pertaining to Muslims, if despite modern legislation, Hindu men have continued to be bigamous, indulge in extramarital affairs, domestic violence, female feticide, etc., then when it stop with Uniform Civil Code? What is imperative is to strengthen programs that benefit women, that allow them independent decision making, etc. However, it may require actionable policies rather than empty one nation, one everything slogans. The need of the hour is not asking for Article 44, but what about Article 47? Will there be a debate on Article 47? Will the great Arnab Goswami have a debate on Article 47? If an Article 47 debate is started, there will be riots on Friday nights in the streets of Mumbai and Bengaluru and Hyderabad. Let me conclude by saying, by quoting what the late Ram Jethmalani had said. Mr. Ram Jethmalani termed as unnecessary a debate or introduction of Uniform Civil Code in the country and said, what the country needed was uniform justice for all its citizens. I thank you very much, Mr. Mahesh Jethmalani, for inviting me to this 17th Ram Jethmalani Memorial Lecture. Thank you very much, Arnab.
First, I would like to pay my tributes to late Shri Ram Jethmalani ji, who was, as rightly pointed out by Tusharji, not only a great legal mind, highly erudite, and his whether arguments in the courts or speeches in parliament, they were marked by wit and humor. And I am personally beneficiary, recipient of his love and affection. So I remember him fondly and would like to compliment Maheshji for organizing this lecture in his name on a subject I am sure he must have been greatly interested in. Before I come to the topic, I would like to make reference to a noting on an official file by George Hamilton, who was Secretary of State for India soon after the British Crown had taken over the administration from East India Company after 1857. Now, while sitting in London, he is writing on this file which has gone from India. He says, one hardly knows what to wish for India. Unity of ideas and actions would be very dangerous politically. These are very ringing words. He says, if we do anything which creates unity of ideas and actions among Indians, that would be very dangerous politically. Divergence of ideas and collision are administratively troublesome. Of the later, of the two, the later is least risky, though it throws anxiety and responsibility upon the officers on the spot where friction exists. So all the, whether they were constitutional measures, the policies, executive action, everything was decided in the light of this noting of the topmost officer, of the topmost British officer as far as India is concerned. So our problem is not really Uniform Civil Code. Our problem is the colonial hangover we have not been able to get rid of. We still use, not just in the on the matter of Uniform Civil Code, even otherwise, we continue to use the same language and idiom which we have inherited from the colonial powers. Do not forget that British India, the building block of India was community. The Britishers never recognized us as a nation. They said we are a conglomeration of communities, social groups. No one can have the right to speak on behalf of all Indians. In 1947, we became free. In 1949, we adopted our new constitution. According to the new constitution, it is not the communities which are the building block. It is the individual citizen who is the building block of Indian nation, of India as a state. Even if you look at Article 25, which is invoked frequently when demands are made in the name of religion to allow things which essentially are of separatist nature. Read the article carefully. The article does not give this right to the community. This is an individual's right. And I will give you an example. Say, for instance, in the Shah Bano case, when government decided to overturn the judgment of the Supreme Court, the Muslims of India, majority might have been of one opinion, but they all were not of one opinion. Now, when government accepted the interpretation of one group, then what practically it means? Practically, it means that you have those who did not differ with the interpretation of the Muslim personal law board. You denied them the right to religion. Why? Because one group's opinion you imposed on everybody. Just now, Maheshji said that 1986 Shah Bano case, the remarks of Chief Justice Chandrachud, they failed to evoke any response from the politicians. And Arnabji, you also repeated the same thing. That is not right. It evoked response, but in the reverse direction. India at the time of independence or at the time of the making of the constitution had accepted that personal laws, family laws, we will accept the religious laws. We had accepted that. But in 1986, after the remarks of Justice Chandrachud, when we tried to deny protection of section, I think it is 425 or no, 125. 125. When we decided to deny protection to Muslim women under section 125 of CRPC, then we started marching in the opposite direction. Whereas the obligation, the constitutional obligation of the government was to create conducive atmosphere in the country so that uniform civil code can become possible. When the constitutional fathers, when they had inserted Article 44 in the Constitution, that represented advancement of thought, and the framers fondly hoped that with the advancement of education and the strengthening of national spirit, it would soon become a reality. But as I said, in fact, if you look at the proceedings of the Constituent Assembly, the framers of the Constitution were deeply aware that India had to suffer long spell of foreign domination or slavery because our society was divided from within. So they took two major steps. And the proceedings of the Constituent Assembly will make it clear to you that actually they contemplated three major steps, but they took two major steps. One was abolition of untouchability, and the other was abolition of separate electorate. Because through the instrumentality of caste which rested on untouchability, this society was deeply divided from within. And because of the separate electorate which was introduced by the Britishers, and that you should consider in the light of the noting of George Hamilton, why separate electorate was introduced. The separate electorate, if caste divided people on the social lines, separate electorate divided people on the religious lines. And the Constituent Assembly took these two major decisions to abolish both untouchability and the separate electorate. And regarding the third, they inserted a provision in the directive principles of policy, because it becomes fidelity to the ideal. We should be very faithful to the ideals. At the same time, one has to be sensitive to the actual. And they were aware that we have, not only that we have attained freedom after a long period of time, but our country has been partitioned. And our country partition was demanded on the basis that in united India, the religion of one community will be in danger, the culture will be in danger, everything which they have, that will be in danger. And that is the reason that you can, I would like to refer to an interview which was given by Pandit Jawaharlal Nehru to Taya Zinkin. Taya Zinkin was wife of an Indian, of an ICS officer who was British, who had stayed in India after India became free. But at the time when he was retiring, Taya Zinkin, who used to work for Guardian, she interviewed Pandit Jawaharlal Nehru. And during the course of this long interview, Taya Zinkin asked Panditji, who was a leading light of the freedom movement as well, she asked him, what you consider your life's greatest achievement? And Panditji unhesitatingly said, I was able to secure rights for my Hindu sisters, which were denied to them for centuries. And what was your major disappointment so far? And Panditji again said, he said, the thing which I did for my Hindu sisters, I could not do for my Muslim sisters. So we must, after all, now the freedom is 75 years old. The uniform civil code is not to create uniformity in this country. This country has always cherished diversity. This country, right from the beginning of its civilizational journey, it has made the proclamation, Ekam Sat Vipra Bahuda Vadanti. This country has said, Bharateshu Striya Pursho Nana Varna Pirkitite, Nana De Varchane Yukta Nana Karmani Kurvate. The people of India, they have different racial stock. Their customs and their rituals are different. Their modes of worship are different. We have always cherished diversity. We have always believed that all people should not be confined to one single interpretation of reality. Everyone, the truth is one, the reality is one, the Supreme Spirit is one, but it is described variously. And that is what Swami Vivekananda had also referred to in his speech in the Parliament of Religions. So this is not about, because if people apprehend, they fear that this will be used to create uniformity, then I ask the question that the Hindu law is applicable not only to the Hindus, it is applicable to the Sikhs, to the Buddhists, to the Jain. Has that law been able to create uniformity among all these communities? not even among Hindus. The systems, the rituals, the customs are different in northern India, they are different in South India. The purpose is not to create some kind of imposed uniformity. No. The purpose of the Uniform Civil Code, as it was envisaged by the honorable members of the Constituent Assembly, was to create uniformity of justice, uniformity of rights and obligations which arise from certain facts like marriage. It is the uniformity of justice, not uniformity, and nobody is interested. Sometimes point is made that this is some hidden agenda, particularly the name of the RSS is mentioned. Here I have with me an interview which was given by RSS chief, and mind you, I'm quoting it. I do not totally agree with this interview. But on the question of uniformity, I am referring to this interview. This interview he gave to organizer on 26 August 1972. And the question was asked by Mr. Malkani, who was later Rajya Sabha member, Lieutenant Governor of Puducherry. He asked this question: you don't think that a uniform civil code is necessary for promoting the feeling of nationalism? And I don't. This might surprise you or many others. I see. Then Guru Golwalkar ji said that Europe is a young continent. Their civilization is new. Our civilization is time-tested civilization. We diversity. We cherish diversity. So this fear should be, they should get rid of this fear that there is any design behind this constitutional proposal. Uniform civil code, any if it really is going to create problems as far as the practice of religion is concerned, then my question is that the Muslims who live in Europe, Muslims who live in United States of America, even Muslims who live in a Muslim country like Turkey, have they become less Muslim? This Muslim personal law, which people try to preserve, this is not applicable even in India, in all these states. Goa has a uniform civil code. Kashmir, this law is not applied. Are these people less Muslims? And secondly, because the question of religion is brought into this issue, therefore I would like to quote something from the religious scripture. Constitution of a country in Arabic is described as misaq, covenant, some great understanding which has been reached. Now the question is that who are the members of the Constituent Assembly? I don't want to mention other names, but Maulana Abul Kalam Azad was also there. There were many other Muslims there. Now, and I'm really surprised when I see anybody who has taken oath of the Constitution. And it is essential to take oath of the Constitution if you become member of any elected body, even as a citizen. When you participate in certain activities, you have to take oath of the Constitution. So how anybody who has taken oath of the Constitution can, if they argue that the time is not yet right, let us wait for some more time, I can understand. I may differ with that viewpoint. But when they outrightly oppose Uniform Civil Code, I am surprised that are they aware the oath which they have taken to uphold the constitution of the country, and they do it in the name of Islam. And Islam views very negatively those who break the promise which they have made. And one of the verses of the Quran says, Allazina yanquduna ahdallahi min ba'di misaqihi wa yaqta'una ma amara Allahu bihi an yusala. And those who break the covenant after it is ratified. Constitution is misa. And then further, again, because opposition is uniform civil code is opposed in the name of religion, therefore I am relying on the scripture. Otherwise, there was no need for me. Further, it is said that, I have not found in any book, if anybody, any scholar, or any person who claims as representative or is speaking on taking into consideration the religious susceptibilities, if they can enlighten us that is there anything written anywhere where which says that the criminal law of Islam is less important and personal law of Islam is more important, mercantile law is less important, only the family law, where